I am living flesh and blood human. Government has taken that name and made an all caps name. So it will go to the Supreme Court. I promise you.
You understand that you've been charged in this case with cocaine, heroin, or another narcotic. The maximum penalty for that offense is up to 4 years in prison.
No matter what you do to me, I will get out of it, and there will be lawsuits.
First, let me ask the attorneys to place their appearances on the.
Phoebe Mir on behalf of the people.
James Daly on behalf of the defendant.
All right. And we do
I
have.
never asked for an attorney. I said I would be representing myself in appropriate persona. This is just one way to railroad me. That's all. Get me in your jurisdiction.
All right. Mr. Daly, maybe you or Ms. Mir, maybe you can fill me in on the status of the.
Yes, Your Honor. I remember now. We did have an exam in this matter, and Mr. Mattson did represent himself at the preliminary exam. And then Mr. Mattson, then once it was bound over, did fail to appear here in circuit court. So now that he is incarcerated, whereas before he was not, I guess if we just go through whether or not he wants an attorney or still wants to represent himself, since we have had an exam in this matter, once he makes his intentions known on the record, then we can proceed with him still being pro per. But I would like to go through and make sure he is knowingly making.
All right.
Normally,
Okay. Yeah, Mr. Mattson, just let me sort this out a little bit. Mr. Daly, have you been appointed as standby, or what exactly is your status?
I was appointed as standby, Your Honor. Mr. Mattson and we get along fine. He's a pleasant individual to talk to, but he wants absolutely none of my legal input. Basically, he has a theory that I don't believe is justified under the laws of the state of Michigan.
Okay.
And I've indicated that to him.
All right. We are back on the record then in the matter of People versus Robert Mattson. Sir, you are Robert Joseph Mattson, correct?
I am an attorney for the all caps name Robert Joseph Mattson. I am living flesh and blood human. Upper and lowercase Robert Joseph Mattson. That is my name.
All right.
As shown on my birth certificate, live birth, that would be me, as understood that the government has taken that name and made an all caps name, tried to be, to claim an account over that name, which to do business with.
All right. Sir, do you understand that you have a right to be represented by an attorney in this matter?
I do understand that.
Do you also understand that if you want an attorney and you can't afford one, that you can tell me that and I would appoint one for you at public expense?
UCC 1-308, all rights reserved. By me answering and speaking to you at this time, doesn't mean that I'm in any way being given any kind of authority over my body to you at this time.
Okay.
Your Honor?
I will note, sir, your objection to my jurisdiction over you, and I will preserve that for the record. As
Your Honor,
discussed in your hearing on Monday, it is my position that this court does have jurisdiction over you, and I am going to proceed as such. And
yes, sir.
Again, your objection is preserved for the record, and if you would like to file an appeal, if that becomes necessary at a later date, you'll have the ability to do that.
Actually, I think I can do something a little quicker. I like to exercise my rights to subrogation, have the prosecutor file my right to subrogation, or certify my right to subrogation at this time. It's an undeniable right. Subrogation is the removal of a third party. It's in the Black Laws Dictionary, 6th edition. Also the Bouvier Law Dictionary, 2nd edition, that the removal of third party would be the prosecutor in this case.
All right. I'll note that request for the record and find that there is no right to subrogation in a criminal matter. And so I'm going to deny that request. Again, your objection will be noted for the record. And if you feel you need to appeal that decision at a later date, you will have the ability to do that. You understand, sir? You understand, sir? That you understand, sir? Sir, please let me speak. Do you understand, as I asked earlier, that if you can't afford an attorney and you want one, that the court would appoint one for you at public expense?
Do not want one. Thank you.
Okay.
I am not a U.S. citizen. I am sovereign. Separated myself from the U.S. government back in 2018.
Again, it's preserved for the record, and you can appeal it to the Michigan Court of Appeals if you would like to do that.
Well, definitely, it's fraud. American jurisprudence guaranteed fraud. I studied it up and down. I know it all too well, so it will go to the Supreme Court. I promise you.
Okay.
As of right now, for the record, and let the record reflect any objections or denials that you keep denying me, that I'm asking you to file a 1090 an OID 1099 for the prosecutor, because the prosecutor is using my name to do business, and I will prepare the 1096 and the 1099A. So this court proceeding is going to go on and have a jury trial. It's going to be sovereign people, secure party creditors at my status. And also, you're going to be filing that OID 1099 for the prosecutor.
Right, sir. Do you understand that you've been charged with possession of a controlled substance in this case, and that the maximum penalty for that offense? Mr. Sir, I'm going to ask you to let me finish when I'm speaking. I've done the same for you, and I'd ask you to do the same for me.
Your Honor. Yes, sir.
You understand that you've been charged in this case with possession of a controlled substance, cocaine, heroin, or another narcotic of less than 25 grams, that the maximum penalty for that offense is up to 4 years in prison.
I do not understand the nature and the cause of the crime.
All right. I'm advising you at this point that you have been charged with possession of a controlled substance, cocaine, heroin, or another narcotic of less than 25 grams, and that the maximum penalty for that offense is up to 4 years in prison. I'm also advising you that you've been charged with operating on a suspended license. A license has been suspended, revoked, or denied, that there is a second offense notice with that, and therefore the maximum penalty for that offense is up to 1 year in jail and or a $1,000 fine. I'm also advising you that you have been charged in this case with alcohol, open container in a vehicle, and the maximum penalty for that offense is up to 90 days in jail. This also carries a habitual offender second offense notice, which increases the potential penalty to 1.5 times the maximum sentence on the primary offense. As I've indicated, you do have the opportunity to consult with a lawyer if you wanted one, and if you can't afford one, I would appoint one for you at public expense. Mr. Manson, or sir, I believe you've referenced this already, but do you have any training in the law?
Yes, I do.
Would you tell me just a little bit what that training is?
Common law.
Okay, and have you studied that yourself?
Yes, I have, along with a couple other people.
Okay, you understand that the law in this case consists of criminal statutes that you're alleged to violate, the Michigan Court Rules of Criminal Procedure, Michigan Court Rules on Evidence, and any number of decisions from the Michigan Supreme Court and Court of Appeals which interpret those statutes and rules.
I understand that the Michigan Supreme Court offers 2 different types of courts: common law court, tribunal, military maritime court, which this court is operating under, and they're not operating properly with me at this time.
Right. You understand that the prosecutor
Sorry, go ahead.
You understand that the prosecutor that's going to try this case has been to law school, has had significant education and a number of years of experience and training in the law.
And that's perfectly fine.
All right. Do you understand that if you do represent yourself, you're going to be required to follow the Michigan Court Rules and the Rules of Evidence?
I'm going to be operating under common law laws. That's what I should be under as common law. If this is not a common law court, I don't belong here.
All right. You understand that I know you've made that objection and then made it several times, but I'm going to conduct a trial on this matter that's going to require you to follow the Michigan court rules and the Michigan rules of evidence. You understand that?
Yes, sir.
And you understand that those rules are going to determine whether you can do things like ask certain questions of witnesses, admit documents, photographs, or any other evidence that you might have.
Yes, sir.
You understand that you're going to be responsible for the jury selection process, and that's also governed by court rules, which determine when you can appropriately challenge a witness.
Yes, sir.
Do you understand that in order to become a licensed attorney to practice in Michigan, it typically requires at least 3 years of law school and passing a bar exam to show that you have a sufficient knowledge to work as an attorney?
Not a part of the state of Michigan. I am the Republic of Michigan, Michigan Republic.
Okay, do you understand that in order, if you wanted to have a license to practice law in Michigan, you would need to go to law school and pass the bar exam?
No, incorrect.
Okay, do you understand that the attorneys handling your case, the prosecutor is going to have a license to practice law in Michigan that meets the requirements that I've already indicated to you?
Which makes any judge or prosecutor or attorney a part of Great Britain, foreigners, only operating under the foreign sovereign immunity, which actually I have myself and trumps over all years.
All right. I appreciate your objection to this court's jurisdiction, and I've ruled on that. And again, I'm not going to change the ruling. You can appeal that to the Court of Appeals in the Supreme Court if you wish at the appropriate time. Do you understand that? Definitely. At least in my opinion, I think you're going to be at a significant disadvantage in this case if you attempt to represent yourself with having a licensed attorney on the other side.
I already am. I'm dealing with the wolves. There's no fair trial in this military maritime courts. There's nothing fair about it. I mean, you've already made your determination the other day that I was not guilty. Last time I seen you in court. Let the record reflect that. I mean, you sit there and enter the plea and not guilty.
Sir, as I indicated to you at that hearing, I entered a not guilty plea for you. That is not my determination that you are not guilty of what's been alleged.
It's working from the bench, Your Honor. It's not your job to enter a plea. It's mine or my attorney's, which in this case, it would be mine. So the court has already made a determination that I am not guilty.
All right, sir, are you sure that you want to represent yourself knowing all of the disadvantages, or at least what I believe to be the disadvantages that you face?
Yes.
And is that decision absolute and unequivocal?
Absolute and unequivocal.
Do you have any hesitation about the fact that you want to
trial will be my peers. My peers will be secure party creditors.
Do you have any hesitation?
The jury.
Do you have any hesitation about the fact that you want to represent yourself?
No. No matter what you do to me, I will get out of it, and there will be lawsuits.
All right. At this point, I'm going to determine that Mr. Mattson has made an unequivocal request to represent himself. The right has been asserted knowingly and voluntarily after discussion advising him of the disadvantages of self-representation.
Mr. Daly.
And at this point, I will appoint.
Will Mr. Daly be willing to come over and talk to me here after we get done with this video screen conference?
I will appoint Mr. Daly as a standby counsel. And sir, you're asking.
Can I speak with him about a couple of things?
I can put you in a breakout session so that you can speak to him over video conference privately.
Let me do that, please.
Okay. All right. Mr. Mattson should be back from the breakout session shortly.
Your Honor, I'm going to be going over and talking to Mr. Mattson. I still think after my discussion with him, there may be some ways to work this out.
Okay. He should be back from the breakout session any second here.
They're back on.
All right, we do have Mr. Mattson back from the breakout session with Mr. Daly at this point. Mr. Daly, you had indicated to me off the record that you were going to have an in-person meeting with Mr. Mattson at this point. Is that correct?
I will. I can't get that done till Monday, but I've already indicated to him I'll do it on Monday.
Okay, and sir, is that something that you want to do, is have an in-person meeting with Mr. Daly?
Yeah, I want to see if there's something that we can work out here just to save time and hassle and a lot of grief between all of us.
Okay.
But I really would like to speak to Mr. Daly one last time before.
All right. Okay, so this is an arraignment. I presume, Mr. Mattson, that you'd like to enter a not guilty plea until you've had an opportunity to speak with Mr. Daly. Is that correct?
Yeah, I'm not entering any plea until I speak with Mr. Daly and he speaks with the prosecutor.
Based on that, I'm going to find that Mr. Mattson stood mute to the charge, and I'll enter a not guilty plea on his behalf. And I'll set this then for a pre-trial.
I object to that, Judge. You cannot enter, that's working from the bench, you cannot enter a not guilty plea on my behalf. Either me or my attorney has to do that. I mean, has the court again made a determination that I'm not guilty?
All right, as I've explained previously, it's not a determination that you're not guilty. It is an entry of a plea based upon your not entering a plea at the arraignment. I will set a pretrial for December 1st at 8 a.m. And that will give time for Mr. Daly to have an in-person meeting with you at the jail.
Can I speak with Mr. Daly here again in private?
I'll just go over to the jail and see him on Monday, Judge.
Okay, he's going to come over to the jail and see you in person on Monday. So you can tell the officer that's with you that you're done in court for today.
Okay, how about next time a bond, PR bond, next time I go to court? All right.
With respect to the bond for right now, I'm going to leave it as it's currently set based on prior failure to appear at an arraignment.
I did appear. You wasn't there. I went to the clerk's office, then I went on television screen for Anna Marie's court. It kept clicking me off for about 45 minutes. And after that, I gave up. I did appear. I think that's a due process thing.
Subscribe my YouTube channel, Courtroom Shock USA.